you start taking on a negative tone, did anybody from the department ever suggest any other type of course of action to help the visits be more positive?
No, sir. They both times it was different with Miss Tara and then this Miss Rachel Fuller or Fulton. Anyway, it's more or less they run the program, wouldn't let me and my son have our time, and that really injured everything we had going. And this is where I'm at now.
If they had offered something as an alternative or something to try to remedy it, is that something, would you have been willing to do anything to participate?
Yes, sir. That's what I was wanting and hoping for in the beginning. That's what I was under the impression, Miss Cynthia Corey, as my other attorney, we were going to get the visits, the 2-week visits, and have regular visits on Zoom, and it just all went chaos. And I don't know. It's like he's been turned against me.
Okay. Did you heard Manny testifying here in court, and you seemed to be a little bit upset by some of the text messages. Were you aware it was bothering him when you were texting him?
No, I didn't realize that. I mean, I was talking to him as a child, as my son, as a young adult. I mean, I know 15 years old is really basic age to be talking about not all adult things, but some certain adult things. And there's things he knows that I didn't know at that age and finds to be kind of puzzling, but that's beside the point.
I didn't really understand a lot of that answer. Could you just repeat that a little slower? I was kind of losing you. I said, were you aware? Did everybody else understand that? Okay. I said, were you aware that some of the messages that you were sending your son were upsetting him?
No, sir. No, he didn't tell me nothing about it, and it resumed on. And
it wasn't muted.
It wasn't muted.
I'm here. I can't hear you, Miss Lisa. I can't hear you. Nothing.
Can you hear? No,
yes.
You can't hear us either.
Yes, I can hear you now.
Oh, you can hear me?
Yes.
Oh, okay, good. All right. Mr. Karabidian is going to ask you the question again.
Yes, you heard your son testifying that he was getting upset. He used a different word, but he was getting upset. It was bothering him, some of these messages coming in. And he said he was overwhelmed. He was uncomfortable. Were you aware at the time when you were sending these messages that he was responding that way?
No, I wasn't aware.
Okay. If you were aware of that, it was something that maybe your son felt you were moving too fast. Would you have changed your behavior at all?
Objection, speculation.
Overruled. You may answer.
Can you repeat the question?
I just said if you were aware it was having a negative effect on your son, is that something you were capable of changing your behavior?
Yes, sir. I'm willing to change and adapt to whatever. That's what I'm saying. We never had time to adapt to each other to get to form a relationship to be able to bond, and that's why this is this way.
Was your son's negative reaction to some of your texts and behaviors, was it ever discussed in the therapeutic visits with the counselor?
No, sir. It wasn't really no kind of open conversation like that. No.
Did anybody from the department, any of the caseworkers or anybody else raise that with you? That he was having a negative reaction?
No, sir, it's been that way from the beginning. I haven't had no help. I've had to find and feel my way through this like a blind man, and it's been awful.
Okay. Now I want to ask you one other thing about the restraining order, because I'm a little unclear here. From what you testified to, you're the one who filed something back in May of this year to get that restraining order in Massachusetts lifted, right? Yes,
sir, I did.
Did you file an actual motion, or did you just file a letter to the court?
A letter. I filed a letter.
Did you actually do a hearing, or was it done without a hearing?
Yes, it was a hearing, and I sent you copies of it. Them releasing and vacating the restraint, the abuse prevention order 2098.
Now, what was the reason that it took so long to figure out how to get that lifted? How'd you finally determine that writing a letter was how to lift it?
Well, first off, I knew that it was a false restraining order, abuse prevention. I knew it was false from the start because there was no evidence, no proof of anything. So I just let it go on, and we were communicating every so often through the internet and through the phone. So I assumed everything was okay, and I wasn't living in Massachusetts, so I wasn't worried about the charge that I had on me, and I violated it 3 times due to her. But I was okay with it because I wasn't ever planning to go to Massachusetts because there was no way to come and fight when I had restraining order violations. Therefore, I'd have been put in jail before I could even contested fighting to try to get any kind of rights or custody with my son. Huh?
Okay. I'm getting a little confused by that answer. So you didn't do anything about the restraining order because why you weren't going to Massachusetts? Is that what you said? Or you just were having, or you were talking to Tracy? What was, I couldn't make out that reason. Can you repeat that?
I knew the restraining order was there. There was nothing I could do about it because I had violated it 3 times. So therefore, I couldn't come up there and fight this case with DCF or the Massachusetts court due to the restraining order violations. 3 of them, I would have been locked up, therefore not been able to fight the case. So I just let it go because me and Tracy was having communication, and my son, me and him had a little communication before all this and before she died. So I was okay with the way things was because I knew she was going to be leaving. She was coming to Mississippi, but I wouldn't pay for her, Gary's travel to come here to Mississippi. So anyway, she got back with the Emmanuel, and that's why we're here.
Objection, narrative at this point, non-responsive.
I'm trying to figure out how
Sustained.
I'm hearing him talking. His mouth isn't moving. What the technology?
Mr. Roach?
Yes, I'm here.
All right, so just leave yourself on unmuted right now. You can keep it on unmute.
I don't have any more questions for
Nope.
your father anyway.
No other questions? All right, so let me see if any of the other attorneys have any questions. Ms. Ward? Ms. Goodine? Mr. Nelson?
No questions, Your Honor.
Defense would rest at this point.
Thank you. Your testimony is complete then. Defense rests. Moving back to the department, any rebuttal testimony or evidence?
No, Your Honor. Ready for
Okay.
closing.
All right, department rests. Closings then?
So, Your Honor, I will adopt, if it pleases the court, my response to the motion for dismissal and incorporate that. I've gone over the cases as far as abandonment go. I mean, it's clear Mr. Roach has made no effort whatsoever to be involved in Manny's life. The guardian ad litem testimony, particularly, the 30 ranting text that he never asked about Manny. It's all about Mr. Roach, Mr. Roach, Mr. Roach. Mr. Roach's rebuttal testimony that, well, I didn't do anything in the injunction because I already had 2 violations of the injunction against me. So I can't go to Massachusetts. That doesn't help. It's clear that there is no relationship here whatsoever. And it sounds like there's good reason for that. But the case law is clear. I mean, the fact that he didn't take the efforts to pay support, he had the ability, he's been working. I mean, even if he couldn't pay much, the fact is he hasn't paid anything in years other than, his stimulus check being, taken by the government. It's not his action, it's the government's action. One thing I would like to cover beyond that is as far as something Mr. Karabidian brought up about, well, maybe, if he had a chance to do services, that's not an option before the court. In EA 332 Southern 3rd 493 at 500, this recent Florida 4th, the court need not conduct a least restrictive means analysis when it's one of the grounds for expedited termination. This is illustrated in another case that I sent out after the fact to the court and the parties, EK v. DCF 326 Southern 3rd 149, 154 to 155. And this is actually a case where the court found grounds for egregious abuse. And the court in that case said, well, but maybe we can provide some services. Maybe we can give this, dad a chance. And the DCA, this is actually, I'm sorry.
Wow.
First DCA is EK?
Thank you, first.
Sure.
I forgot to put that on my notes. Said no, where there's grounds for the expedited termination of parental rights, there is no least restrictive means element to be proven. The court had no authority to deny the petition to order services under those circumstances. So where the legislature has said, under these conditions, you don't need a case plan, they need, under these conditions, you don't need a case plan. The goal of the Department of Children and Families in all cases is to maintain families, put families back together. Nowhere in our mandate is, let's build a new family that has never existed because the father never took any effort to make a difference in this young man's life, not financially, not emotionally. As far as manifest best interest, if the court wants me to go through every topic, I will, but I think the general parameter is Mr. Roach hasn't made any effort to provide financially, any effort to provide emotionally for the child. In fact, the interaction he was allowed to have with Manny was negative, very negative, to the point where Manny wants nothing to do with this man. He has no capacity whatsoever to care for this child based on his own lack of interest over this child's life. And Manny has a loving family in Massachusetts. We're pending an ICPC. There's other relatives in Massachusetts. There's very little likelihood that Manny would end up in extended foster care. He needs to be freed from adoption. And moreover, there needs to be no further contact with Mr. Roach whatsoever. Thank you.
Ms. Goodine.
Young man, he needs permanency. He needs permanency, so he no longer has to fear that he could be sent to his father. He needs permanency, to know that he is going to go into it.
Hello, can she get closer to the microphone? I can't understand what she's saying.
Can you get closer? I can hear you, but it's hard, probably for recording to hear you.
I concur or adopt the arguments made by the department, but I would like to add that Manny, who is going to be 15, he is a young man, he needs to have permanency. He needs to have peace of mind that he is not going to be sent to live with a person that has never been his father. And he needs to be relieved of that fear and sent to Massachusetts to live with family members, the only family that he knows. Thank you.
Ms. Ward?
We adopt the position of the Department of Children and Families, and we'd also like to add, this week we've heard extensive testimony about the relationship between Jerry Roach and Manny Lucier. The only issue before this court is if Jerry Roach has abandoned the minor child Manny Lucier pursuant to Chapter 39-806-1B and 3901 subsection 1. The testimony was clear. For 14 years, Mr. Roach did nothing to get to know his child. Prior to the restraining order, for the first year and a half of Manny's young life, Mr. Roach did not meet his baby or hold his baby. Once the restraining order was in place, he did nothing more to contact his child. Mr. Roach, by his own admission, was able to vacate the restraining order by going online and filling out a form. He did not need funds to hire an attorney, and he did not need any special skills to vacate the restraining order in the end. Yet, for well over a decade, he did nothing to vacate the restraining order or to seek any sort of relationship with his child. Both Manny and Mr. Roach's testimony was clear. They have never met. They've spoken on the phone a handful of times and have had 2 therapeutically supervised visits. This does not form what the statute defines as a substantial and positive relationship with the child. Since the restraining order was lifted, Manny has tried to engage in a relationship with Mr. Roach. However, this has not been a positive relationship. Instead of respecting that Manny has another man in his life that he views as his father and a family in Massachusetts that loves him and misses him, Mr. Roach continuously turns the conversation into his own wants and needs. Through his own testimony, Mr. Roach stated that he didn't know his son, he didn't know his likes and dislikes, and he didn't know how to talk to Manny. Manny testified that the therapeutic sessions were awkward because he felt like Mr. Roach was making him feel guilty for wanting to live with his family in Massachusetts. The court was able to see Manny's entire demeanor change when he was given an opportunity to talk about his family and how loved and comfortable he is with them in Massachusetts. Why was Mr. Roach not able to see this too? In conclusion, the court heard credible evidence that Mr. Roach has no relationship with Manny prior to May of this year, and since then has been unable to establish nor maintain a substantial and positive relationship with him. Simply put, they have no relationship. It would be emotionally damaging to Manny. It would be emotionally damaging to place Manny with Mr. Roach, and it is in Manny's manifest best interest to terminate the parental rights of Jerry Roach. Thank you, Your Honor.
Mr. Karapethy?
Yes, Your Honor. Thinking long and hard about this one, and I don't think I could sit here and honestly ask the court to deny the petition and place this child with the father. That's not really what the father is asking for here. I don't think the testimony would support that type of finding. I think the evidence shows that I don't believe Manny doesn't want to have anything to do with his father. I don't think that's what he said. I mean, initially he said he was excited to talk to his father. He wanted to meet with him. He wanted to talk to him. He just was very clear that he wanted to live with his Uncle Manny in Massachusetts, or Uncle Gary in Massachusetts. It's something that it's a little troubling here that when we look under manifest best interests, I know that's something everybody's been discussing here on the number, I believe it's 10, was the preferences of the child. The court deems it to be a sufficient intelligence, understanding, and experience. We're putting a lot of weight on what this young man is saying, and he also, but look at the circumstances under which he's giving this testimony. The court has to kind of consider that too. I mean, he has mental health diagnosis. He's taking medication for it, which is a good thing that he gets that. But he's also, look at the trauma he's undergone in the past 2 years. His mother died. His grandfather died. The caretaker he had, Mr. Bongiorno, isn't in his life. He's moved from Massachusetts, his only home, to Florida. In 2 weeks after moving to Florida, his mom dies. And then you're kind of thrust into this relationship with the father that he didn't know. He didn't know him. it's something that it's hard to put too much weight on what he's saying, because is he in a position to be making lifetime choices? He's in a position to say, I never want to have any type of contact with my father in the future. I mean, it's not something that we haven't had any expert testimony here, but the testimony, if we had testimony coming in, it would be the same as what they're speculating that would be damaging. Well, I think it'd be damaging to not have any type of relationship at all with your biological father. All the cases we've ever had, that's something that always comes up when you cut off relationship with a parent. It's something that could have long-lasting effects to think about that, because he was excited to talk to him at the beginning, and he said, from his own words, he may want to have some type of relationship in the future with him. He didn't really know about it, but I think it was all based on the fact he didn't want to live with the father right now. So I don't think that that's something that we're asking the court to do. I think when we look back at it, you have to look back at the statute and consider that somebody has to have the ability to do certain things. I'm not sure the father had the ability to be paying, he paid some child support, the testimony was. Was he current? No. Was he paying it? But over the last several years, I don't think he was paying it on a consistent basis. He was working, just doing the gig work, which I don't think was paying him a lot. It was paying very minimal amount, and he was kind of living in looks like a family trailer where he didn't have a lot of expenses. So I'm not sure whether he really had the ability to be paying it, which is one of the grounds the court has to find is under abandonment was they have to make while being able to has made no significant contribution to the child's care or maintenance, or failed to establish and maintain a substantial positive relationship. I'm not sure you have the ability to do so when you have a restraining order. You had a restraining order in place. The mother made a point of getting a restraining order against him in 2008.
Yeah.
She modified it in 2009 to include the child. He was not able to. He actually went to jail for violating the restraining order along with something else. So he didn't have the ability to form this relationship. He was getting updates from Tracy. The testimony was clear that she was updating him with pictures. She was updating him with how he was doing. That was something with the restraining order in place that was sufficient for him. In 2014, he was given an attorney in another DCF case up in Massachusetts, and his testimony was that the attorney was not able to help him out. He's not a lawyer. We're all lawyers in the courtroom. We know things. You could do things. You know where to go to find things. The internet 15 years ago was not the same as it is now. Information was not quite as available. It wasn't as easy. It wasn't as user-friendly. He's not a sophisticated man. He's a man of Mr. Roach. He's a man of limited means. It's something, if he was told by an attorney at a time, we can't do anything about this, he takes their advice.
Yeah.
When he came in here, I guess Ms. Quiros was the attorney before this, and she, I guess, either counseled him or he found it on his own, but he did get the restraining order lifted, which was a good thing because it enabled him to speak to his son. But the problem was the damage was already done. He hasn't talked to his son in 14 years. It's hard to start from scratch. I mean, it's a hard thing. I mean, think about this. He's known he has a son out there. Manny doesn't really know he has a father. When they put them together and they finally start doing their visitation, the father jumps into it. He's all excited about it. This is his son. He hasn't seen his son in 14 years. I would submit to the court, he's being over exuberant. He's overexcited. Some of the things he was talking about, I think, were vaccines, and some of the text messages, vaccines, and rare blood types, and knives and stun guns and things. I didn't grow up in Mississippi, but I know that growing up in the Northeast, that the culture you grow up with in the Northeast is different than you do in the South. And the things that were acceptable for a 13, 14, 15-year-old boy up in New York or Massachusetts or in the Northeast are different than children growing up in Mississippi or Florida. So I don't think the father was saying anything that was totally out of place based on where he grew up. But the problem was he was not being sensitive to Manny's needs. Manny reacted in a very predictable way. He pulled away. When somebody's being a little overbearing on somebody, the other person pulls away. the father was not given a chance to rectify the situation, because as soon as Manny was reacting negatively at that point, the therapeutic visitation stopped totally. There was nothing that was offered to him or Manny that would try to rebuild the relationship they were trying to form at that time. So it's something that I know the department said here in these cases, and the statute was pretty clear there, that says when you're using grounds of abandonment, you're not required to give a case plan. But being not required doesn't mean they're not able to do it. And they did choose to give referrals to Mr. Bongiorno. They did choose to give referrals to Manny. And I submit that when DCF made the choice, even though they weren't required to do something, once they chose to do it, then you have to do it for all the parties involved. You can't just sort of pick and choose and say, because this case was not, when it first came in, wasn't going toward an abandonment ground. They were trying to somehow rebuild this relationship with the father and the son. And if you're going to do it, you have to do it full force, 100%. They did it a little bit, and then when the visits started going south, they just sort of terminated everything. It was nothing, and from what the father testified to, I'm not sure he even knew that Manny was reacting that way. I think probably the first time he was hearing it was when it was coming from, I think somewhere in July, when he said he didn't want to visit anymore, because testimony was he was supposed to go for 2 weeks to go see the grandmother, and that visitation never happened. I think that's the first time the father was sort of on alert that something was going wrong with the visits. I don't think he even understood Manny, the depth of Manny's uncomfortableness dealing with him until that point. But based on all this, I just think it's in the court's, I think it's in the court's power to deny the TPR and either place Manny in a permanent guardianship or give him some kind of legitimate case plan to the father and place the child with Uncle Gary in Massachusetts, if that's what the child